The Code of Criminal Procedure allows you to waive almost any right you are granted by law, but it adds some requirements to make it more difficult for the government to abuse the system. We'll review several requirements for different waivers in this screencast. A defendant in any case may waive any right granted by law unless it is a death penalty case and the defendant is seeking to waive the right to trial by jury. This is the only right in Texas that can't be waived. Upon the start of a trial, a defendant automatically waives their right to object to defect, error, or irregularity in form or substance contained in an information or indictment and may not raise it on appeal. In other words, the defendant can't object to any problems with the documents used to charge him or her after the fact. They must bring it up before the trial starts. Next, no defendant can be convicted of a felony unless convicted by jury or the defendant has waived their right to trial by jury. If a defendant wants to waive their right to trial by jury, the waiver must be in open court, in person, and in writing. The Code of Criminal Procedure next states no conviction may be made unless evidence is presented. This means, even in the case of a plea bargain where no trial is held, evidence of the offense must still be presented. The defendant can waive even this, however, if they agree to waive the appearance, confrontation, and cross-examination of witnesses and consent to a spoken description of the evidence. This must be approved by the court in writing. Many requirements have been presented, but to summarize them all, this statute is designed to prevent a person from being convicted of fabricated or false charges. For example, it prevents an unscrupulous prosecutor or peace officer from filing fake charges and then intimidating a defendant to take a plea bargain. The requirement to present the actual evidence of your guilt, including testimony, seeks to prevent false convictions.